Good afternoon, everyone. Thank you for joining us today for this panel on Justice Alito's impact on criminal law and procedure. My name is Caleb Velker, and I am one of the incoming presidents of the Penn Federalist Society. And it is my honor to introduce our moderator today, Judge Andrew Oldham. Judge Oldham serves as on the United States Court of Appeals for the Fifth Circuit. And before ascending to the bench, Judge Oldham served as general counsel to Texas Governor Greg Abbott. Prior to this, Judge Oldham clerked for Justice Alito on the Supreme Court of the United States and for Judge Santel on the DC Circuit. Judge Oldham earned a BA from the University of Virginia with highest honors, a master's in philosophy, first class with distinction from Cambridge University, and a JD magna cum laude from Harvard Law School. And with that, I will turn it over to Judge Oldham.
Thank you very much. It is a great joy and to be here, a great honor to be here with you all today. It's an incredibly humbling panel to have to participate in, heaven forbid, even moderate. The year I was clerking for Justice Alito, I certainly felt like the man had forgotten more about criminal law than I would ever learn in my entire life. And it was a uniquely distinguished area that he has a ton of experience in. So trying to talk about it is sort of like telling Noah about the flood. But I'm going to do my best, and I have, luckily, the able assistance of three incredibly distinguished panelists. None of them needs an introduction, so I will forego them in the interest of talking about what you really want to hear, which is about Justice Alito and criminal procedure. But I will just say that my friend, certainly my best friend in the federal judiciary, one of my best friends on the planet Earth, Judge Thapar, is to my right, your left. He's a judge on the Sixth Circuit. To his right is Justice Campbell. She's on the Tennessee Supreme Court since 2022. And then to her right is Judge Cassady, who's a commissioner on the Sacramento County Superior Court in California. Judge Cassady and Justice Campbell and I had the distinguished opportunity to clerk for Justice Alito at various times, but not all together. So we have a different perspective on that. And so to kick it off, I'm going to ask each of our panelists to help identify, and maybe we can just go sort of down the row here, and we can sort of give, we'll go one after another, and then we can sort of ping pong a little bit. But why don't you help us by starting with a theme that sort of jumps out to you when we talk about Justice Alito on criminal law or criminal procedure. We'll kind of do them together and then try to unpack them.
Yeah, so I'm honored to go first. I'm honored to be here, always honored to be with my best friend, Andy, and talk about one of the greatest jurists ever to live. So it's really a treat to do this. And my application with Justice Alito is still pending. So I hope someday he'll act on it. But until then, I'll just be a lowly federal court judge that gets to talk about him. And the thing that strikes me, the reason I love the criminal law areas like Justice Alito, I came from practicing criminal law. And so what Justice Alito does that's so unique in my mind and so important is he understands the real world consequences of the Supreme Court's decisions. And I can go through a number of his decisions. I'm not going to do it because I will. Eventually, we all will, I think. But at the outset, if you walk away with one theme here, it's what I always say about Justice Alito is he's a common sense originalist. What I mean is he doesn't let the doctrine run away. And he doesn't get into this runaway originalism. He understands there were certain core concepts that were there at the founding that are pretty clear from the history. And then he understands that the Supreme Court has a lot of time to think and write. And that doesn't play well in the district courts where they have to apply it. And what he's thinking about is how, if there's one common theme about his jurisprudence, it's a reality that whatever they do has real world consequences, especially in the criminal law area. And everyone, a lot of people will say, well, he's trying to achieve X or he's trying to achieve Y. No, he's trying to achieve clarity. And when you go through his criminal law jurisprudence with that idea in mind, that he understands that district courts are going to have to apply this, he understands prosecutors and defense attorneys are going to have to understand it, and you look at each piece of his criminal law jurisprudence, you will see that. And you will see that reality. And I'm just going to start briefly with one case that we all are aware of, which is Jones, which I had the recent obligation to apply, and saw firsthand. In fact, one of my colleagues called me up and said, "You sound like Justice Alito." And I said, "I didn't start there. I just worked through the Jones opinion and then realized that applying it was going to be very, very difficult for district courts." And I had a whole section about how it would be difficult to apply. And it was something that, it took me working through to see, but Justice Alito understood it the minute it showed up on the Supreme Court's desk. Jones is the GPS case. I guess I should reference that, where police were putting GPS on people's cars, and Justice Scalia applied the trespass doctrine. And Justice Alito, right? So wait a minute, what are we doing? This is an easy case under reasonable expectation of privacy, which is the test we have. Why are we making everyone's life more difficult? So I'm going to stop there. I can get into the details of any case, but I want to make sure that we pass it to my much more abler colleagues to my right.
Excellent. Thank you, sir. Justice Campbell, what do you think?
Thank you, Judge Oldham, and thank you to FedSoc for hosting this event. I was so lucky to be able to clerk for Justice Alito, and so it's a real privilege to just be able to talk about what a brilliant jurist he is, and to talk about just the impact he's made on our jurisprudence. And it's a special privilege to be with these co-panelists and to have Judge Oldham moderating. So I want to talk a little bit about Justice Alito's deep appreciation for the role of the legislature in our constitutional design. I think we see this in a lot of his criminal law jurisprudence. The Fourth Amendment certainly is a great example in the search and seizure context, where Justice Alito recognizes that some of these decisions are really difficult, and there's not a clear constitutional prescription for how the case should be resolved. And in that situation, our Constitution really assigns the responsibility of making those sorts of judgments that just involve a balancing of competing interests and a weighing of policy interests to the legislature. And that's true, whether it's Congress or whether it's a state legislature. And we'll talk more about, some cases that illustrate that. But just to begin, I'll piggyback on Judge Thapar's introduction of Jones and point out, something that Justice Alito said there. So, of course, Justice Alito did disagree with the trespass theory that Justice Scalia went with in resolving that case, and would have preferred to apply just the cat's reasonable expectation of privacy test. But he also said, he points out in that case that a legislative body is well situated to gauge changing public attitudes, to draw detailed lines, and to balance privacy and public safety in a comprehensive way. And he expresses a preference for legislative solutions, especially in the area of evolving technology, where we have rapid changes in what technology is available to law enforcement officers. We have a lot of competing interests at stake, and in that situation, the Constitution really preferences the legislature to make those decisions. And it's not so much, although you see some functionalism in the fact that the legislature is really better suited to make those decisions. The judiciary is just not well equipped to make those sorts of judgments. But it's really, I think, driven by the fact that the Constitution has made that choice already, and that the legislature, because of the elected representatives who can better express, the preferences of the citizens, that's who should be making those decisions. So I look forward to talking about that more and digging into the cases more. And thank you again for coming today.
Great. Thank you very much. Commissioner Cassady, what do you think?
All right, well, I should start by telling everyone what a commissioner is, because a few people have asked. So a commissioner, which is where I am, works at the county level. It's almost the sort of state law equivalent of a magistrate judge in the federal system. And we handle cases, sometimes with the party's consent. Other cases, like criminal case, bail hearings, which I handle now, we can handle by statute. And so I'm honored to, with that background to what I'm going to say, I am very honored to be here, especially with such a distinguished panel, and to talk about someone whose jurisprudence is incredible, but also who's had a tremendous impact on the life of me and my family, which is Justice Alito. It was the privilege of a lifetime to clerk for him. Turning to the theme of his jurisprudence that jumps out to me from where I sit is clear, workable rules that show respect for the people who have to follow them and live with their consequences, whether those be good or bad. So when you're at the ground floor of the criminal justice system, which is where I happen to have been for the last 4 years or so as a prosecutor and then as a commissioner, criminal cases are called in courtrooms with overflowing calendars. They're presided over judges who have to quickly apply the law to the facts, then move on because there's scores of other people sitting in the courtroom waiting for their case to be called. These cases are staffed by attorneys on both sides who have often massive caseloads, and the cases themselves started with reports from law enforcement officers who themselves have to make real-time, legally sound judgments in what can be chaotic, rapidly evolving, and dangerous circumstances. And these cases affect real people, all right? It can be crime victims, but it's also the accused and their families. All of their lives are impacted forever by the rules that shape what happens in the case that they happen to be in the courtroom for that day. And I think Justice Alito understands that criminal law and procedure at this level, as it's experienced by the ordinary people who are affected by it and are responsible for making it work, it's relentlessly practical, what we do every day. Everyone at this level benefits from having clear, stable, realistic rules for answering important questions that come up every day. Is this a search or not? What do I need to advise my client for this plea to be valid or not? What findings do I need to make on the record? We benefit from standards that are sensible to common people and capable of being readily comprehended and realistically applied. And people at that level suffer the consequences when well-meaning legal changes are imposed from above that end up being divorced from the real world and that can make things harder for no good reason. And so, to me, Justice Alito's jurisprudence is for these people. He cares about clear, stable, workable standards for police, prosecutors, defense attorneys, and lower courts. And that makes sense because he has real-world experience himself. He was a circuit judge. He has argued in front of the Supreme Court and in front of a jury. There are precious few Supreme Court justices who have that background. He's worked with defense attorneys and FBI agents before, and he's managed a prosecutor's office. He respects the people who have to carry out the court's decisions right now, who don't have the luxury of waiting to act until any problems the court's rule has generated have percolated nicely enough to address them again. He wants judges, police, and everyone else to know exactly what's expected of them on dangerous streets and crowded courtrooms. And he's careful to focus on whether criminal rules make sense now and in the long run. He asks questions like, does this rule reflect facts on the ground and human nature? Does the test we're adopting encourage people to act reasonably in real-life situations? Is the rule consistent with first principles? And I think most importantly, a lot of folks have talked about this today, he cares about the consequences of what the court does. He's uniquely sensitive to the unintended far-ranging effects that judicial decisions can have in this area, especially if the logic the court adopts has no principled stopping point. And I think that's why in some of his writings, the Asteris case, Collins versus Virginia and others, he sometimes stress tests the court's opinion by imagining, right in his own opinion, how a hypothetical ordinary person or a police officer or a trial judge tasked with applying the opinion might react if you explained the court's ruling to them. And for Justice Alito, if they would nod along and say, hey, that makes sense, then that means you're on the right track. But if those people, a normal person who's not on the Supreme Court, would roll their eyes or swear or say, yeah, that just can't be right, then you probably should check your work because to Justice Alito, judging is a practical pursuit that should generally make sense of things. And in my view, that's the unifying theme of his jurisprudence. It's what he's been trying to do for years, and I'm looking forward to discussing it more.
Excellent. Thank you very much. Those are three great themes. Let's try to work through some of them. We've got common sense originalism, what I think of as theory and deference for the idea that we should care deeply about the political branches and courts should be deferential to those political branches' decisions, and then sort of rules, standards, practical consequences, et cetera. So, Justice Thapar, let me start with you. How would you say that Justice Alito's approach to criminal law, criminal procedure, in a common sense originalism way, interacts with non-originalist precedent? You can pick any one that you'd like.
Yeah, so, well, it's interesting, right? Because you could go multiple routes here. So again, back to Katz, that's a good example in Jones where Justice Alito is using Katz, which everyone would acknowledge is non-originalist in form, but he's like, this is the law, it makes sense, it's easier to apply, and I don't want district courts and parties to spend weeks figuring out the idiosyncrasies of trespass law and then trying to apply it. Why? Think if you're an ordinary person trying to figure out if you've got a Fourth Amendment right in that situation. Like, are they really going to comb through, the ancient law to try and figure it out? In other area, if you just think about the simple consequences of, like, confrontation clause, and Justice Alito, in a 2012 case, goes back about DNA, and I think you wrote about this in your article, and he talks about how it's insane that we are going to take the confrontation clause and apply it to something that has nothing to do with what the confrontation clause originally understood. He's like, this doctrine's gotten way off where it started, and now you're applying it in what he perceives as a non-originalist way, and he goes through the history and demonstrates it. And then he says the consequences of that are that maybe it's going to encourage law enforcement not to use more certain methods like DNA, but to use less certain methods like identification, because you can get that in, but you can't get DNA in because of all the hassles of calling 10 different people just to get a piece of DNA evidence in. And so I don't know that it's, the question about non-originalism, I think it's him looking at originalism with a realistic lens and applying it the way he understands it. And to anyone that says he doesn't document it with history, just go read his cases, because he pretty clearly does. He just says, look, at some point that runs out. And to Sarah's point, let's listen to the legislature then. Let's not try and impose our rules. We've got rules of evidence. We've got the rules the legislature puts in place. And why are we then superimposing onto that new rights that no one at the founding contemplated? I can't remember, in one case, you may remember, they go back to like the 1600s in England, and he's like, the founders weren't even thinking about that, and it's pretty clear they weren't thinking about that when they wrote the confrontation clause. Yet you're taking that and adding it to what the founders didn't think about and saying that's part of the confrontation clause. And then you're creating this crazy doctrine where the government has to call 20 witnesses, so they're not going to use scientifically certain evidence. Instead, they're going to use scientifically uncertain, which isn't good for anyone.
Yeah, I should have led with this as a ground rule for our panel at the very beginning. In this particular area of law, we have to be very specific about the cases that we're referencing, because we have multiple Taylors, we have multiple Johnsons, there's at least two Joneses. Yeah. And so if whoever is the first person to raise a case, let's give the audience, for those who do not have the same encyclopedic knowledge as the panel, we'll give them like 2 sentences on what that case was.
Okay.
And if you can't remember, I'm happy to be the resident Jeopardy expert, and I could sort of throw it in like Alex Trebek would or whatever to say, let's set the table for that case, make sure that we're all sort of on the same page. But I think it's very, very helpful. To Justice Campbell, I'm curious what you think about how the political branch deference idea interacts with the justice and his view to the sentencing guidelines, or to the way that the court thinks about the sentencing guidelines. It's a notoriously thorny and very difficult issue. This is the sort of thing that perhaps is of uncommon interest to those of us in law school or those of us who are in the inferior federal courts, because we deal with it every single day. Those who practice may not think about it as much, but I do think it raises some of these broader thematic questions about the way the court interacts with the political branches.
Yeah, so just for a little bit of background, so you may recall the Booker case, which was decided before Justice Alito joined the court. But in that case, the court held the sentencing guidelines, which Congress enacted to be mandatory and binding on federal district courts, to violate the Sixth Amendment, because it required, it would increase the sentence based on findings made by the judge instead of the jury. And as the remedy for that constitutional violation, the court made the guidelines advisory instead of mandatory, rather than requiring that the findings be made by a jury instead of a judge. Just said, well, we can just avoid all of this by making the guidelines advisory instead. And so this spawned additional litigation, including litigation about how an appellate court is supposed to review a sentence imposed by a district court, within this new advisory world. And so one of those cases is a case called Gall. And in that case, the court considered basically how is an appellate court supposed to review a district court's decision to impose an outside the guidelines sentence. And the majority there, Justice Alito was not in the majority, spoiler alert, but the majority said that we apply abusive discretion review. We're not going to require the court to identify some extraordinary circumstance to justify a departure from the guidelines. We're really just going to give a lot of discretion to the court. And Justice Alito parted ways, and he explained that look, like the guidelines may be advisory now instead of mandatory, but the district courts really should still give significant weight to those. And I think part of the reason for that is, look, this is what Congress was trying to get more uniformity and sentencing. And if district courts can just as he put it, just give lip service to the guidelines, but not actually give them any weight, then we're not going to be doing what Congress intended to do with the guidelines. He also pointed out, and Judge Oldham, I think you made this observation in an article that you wrote about his criminal procedure jurisprudence, but he also pointed out, look, the remedy that the court imposed in or outlined in Booker was to cure a Sixth Amendment violation. And we've just gone really, really far afield, from what the remedy was actually supposed to be. And, when you get into appellate review and the standard of review for a district, for a district court's sentencing decision, we're really pretty far from, what the remedy was actually intended to do. And, I want to just quote, I thought this was really good language from Gall, where, so he's pointing out that this review framework that the court had crafted really had nothing to do with the Sixth Amendment violation that was actually at issue in Booker. He says that framework instead implicates, quote, the allocation of the authority to decide issues of substantive sentencing policy, an issue on which the Sixth Amendment says absolutely nothing. And then he continues, the yawning gap between the Sixth Amendment and the court's opinion should be enough to show that the Blakely-Booker line of cases has gone astray. And so, I mean, he's really getting at there, the fact that we're intruding in imposing this standard of review, we're really intruding on, Congress's prerogative to legislate in the area of sentencing. And, that has nothing to do with the Sixth Amendment violation that was actually at issue in Booker.
Yeah, that's very helpful. And it highlights, I think, perhaps another theme we should talk about, or maybe we should circle back to, because this seems to unify a bunch of different doctrines, which is, as you think you've all now pointed out, the justice has this focus on consequences and the consequences of the court's rulings. So let's unpack it a little bit. Some people, and I'm curious what your reactions to this would be, have criticisms of some of Justice Alito's positions in this area of law on the theory that the consequences themselves are untenable. So let's talk about two, for example. One that comes to mind is a majority opinion he wrote in a case called Salinas versus Texas. In Salinas, the suspect is not in custody, but is under questioning from law enforcement and is asked a series of let's just try to say it neutrally, probing questions to which the suspect does not give affirmative speaking answers, but sort of shuffles his feet nervously and does sort of other evasive or nervous kind of behavior, which is then introduced at a subsequent trial. And the question presented is, does this violate the suspect's, defendant's right against self-incrimination / Miranda? One of the criticisms in the dissenting opinions against Justice Alito's, I believe, plurality opinion for the court is, well, this is an absurd consequence that in order to be silent, you must speak. Right, that is that the dissent makes a lot of hay out of this, that like the upshot of saying that this sort of material is admissible is that the only way for you to actually enjoy your rights under Miranda and the 5A self-incrimination clause is to raise your hand and say, I would like to be silent, which is not exactly intuitive. And then the other one that I hear referenced with some regularity is Pena Rodriguez, which is this involves a famously, for those who are not criminal procedure wonks, or substantive criminal law wonks. This is a famous old rule that goes back way before the founding. Judge Thapar mentioned these old rules that we inherited from England, some of which still are in criminal law today. And one of them is the famous rule of juror non-impeachment. So the idea is you absolutely positively, under no set of circumstances, can impeach a jury verdict by using juror testimony after the fact, right? Win or lose, you can't go interview the jurors or get them in the hallway on the way out to the parking lot and say, hey, did you really mean that? No, and then use that to impeach the jury verdict. Famous rule, finality rule, has old, long English pedigree. And in this case, Pena-Rodriguez, the court creates an exception where one of the jurors says, well, I admittedly relied on racial stereotypes in coming up with my jury verdict, and the court says that's admissible and we're going to allow impeachment. Justice Alito dissents. And so some would say that's an untenable consequence of his position. I'm curious, how do you reconcile sort of your views of his law, his approach to these cases, with those, I call them consequentialist criticisms of his position?
Yeah.
In whichever order. Yeah.
Sure. So I can just start briefly. So on Pena-Rodriguez, I mean, I think that a preference for clear rules is always going to be open to the criticism that sometimes it leads to harsh results, right? And that's just something that's sort of baked in, and it can always be tempting when you get a situation where the law has been applied that seems to have been harsh, or where the facts are bad, to try to carve out an exception in order to accomplish a well-meaning goal. And in Pena-Rodriguez itself, the goal was well-meaning, and Justice Alito said so. It's very admirable. It was very bad what happened to go on in the jury room in that case. But I think what Justice Alito might say, and what his jurisprudence shows, is he is very good doctrinally at being able to take a 20,000-foot perspective and take a look at the reason the rule exists in the first place, and then ask whether chipping away at it is going to have any logical stopping point, or if it's going to destroy the salutary reasons for the rule. And so in Pena-Rodriguez itself, Justice Alito said, look, the reason this rule has always existed is to protect the confidentiality of juror communications in much the same way that other evidentiary rules do. We bake in that some things people say to their spouses may be highly probative of guilt, but they're not coming in for other reasons. It prevents harassment of jurors, and it increases finality of the verdicts. And so Justice Alito asked, if we carve out this well-meaning exception, what happens to those goals in the long run? And can this idea be cabined? Maybe someone in the next case, it turns out that a juror says, my colleagues were biased against the defendant because of their religion or because of their sex or some other thing. And Justice Alito's point was, from the standpoint of the defendant, limiting the exception to race doesn't make a whole lot of sense, which might be, so in other words, you then have to just unravel the rule and it can't exist, which then in his view can mean that something's gone awry with your reasoning.
Mm-hmm. I just want to add one excellent to that excellent points on that. The other thing, and I think you referenced this, is we don't want, after every verdict, to be diving into what the jury deliberated about, and we want them to feel free and comfortable. I mean, one of your goals as a district judge or anyone that deals with juries is to make them feel comfortable and understand that whatever they do and whatever they're thinking, it's not going to come out in the future. And as soon as you start diving in and open the door, the logic that Justice Alito's pointing to is, where does that stop? And what's the ramifications for that on our entire jury system that's built on this, right? That we're going to allow juries to deliberate. We're going to allow them to say whatever they want. We're going to allow them to work together and work through their issues. That's the wisdom of the 12-person jury. And so Justice Alito sees that, and as soon as you start opening the door, and we can talk about this throughout his jurisprudence, he'll predict something, and it almost always comes true down the road, that the consequences are exactly what he said they would be.
Mm-hmm. It's true. Justice Campbell?
Yeah, I don't have much to add to that, but just that, I think the critics tend to focus more on seeming unfairness in a particular case, whereas I think, the practical consequences with which Justice Alito is concerned are the systemic practical consequences and the things that I think no one else on the court is really able to foresee or predict as effectively as he can. And I think it's that focus on the broader practical consequences, of a particular case that has made him, I think, so effective as a justice.
Yeah, I'm curious, maybe Justice Campbell, I could start with you on this next one, because it hinges a little bit on Gall, but others feel free to jump in. So as you pointed out, the justices said, look, deference to the political branches, importance of the 6A jury right, we need to be really limited in the way that we're sort of upturning the way Congress designed the sentencing scheme, and there should be some more deference given to Congress in the way that they wanted the guidelines to be mandatory. Maybe they can't be totally mandatory, but they should be sort of closer to mandatory than totally permissive, or just lip service, as you say. I'm curious if we took a poll of the Supreme Court today, on a day that we got a 9-0 decision from the Supreme Court, I'm betting they would be 9-0 on their general dissatisfaction about the way the sentencing guideline scheme works. It doesn't seem like any justice is particularly happy with the way that it's operating at the moment. And I'm quite confident that if you took a poll of Court of Appeals judges across the country, we'd be unanimous in dissatisfaction about the way it works as sort of appellate review. One of the things that's most surreal from a Court of Appeals perspective is that when it comes, we see guidelines sentencing appeals all the time, every day. For those in the room who are aspiring to be law clerks in the federal system, you'll see them all the time, every day. And we routinely have to hold that there is plain error under the sentencing guidelines for errors that are neither plain to, like, in the normal way that people understand them to be, or even erroneous at the time that the district judge did, for example, a sentencing guidelines calculation, right? So it leads to all of these very odd results that are very difficult to understand. And I'm curious if we could just do a thought experiment. Do you think the world would look different or better from a consequentialist perspective if Justice Alito had prevailed in Gall? And then you run that forward, whatever it is, 9 years to today, or I guess 19 years to today.
Yeah, I mean, I think it would depend in part on like what consequentialist goal specifically, are we looking at? Is it more uniformity? Is it, I think certainly if the goal is more uniformity, which is what Congress was trying to do with mandatory sentencing guidelines, then yes, I think requiring district courts to really give significant weight to those guidelines would absolutely, I think, have led to more uniformity in sentencing. I think in terms of just overall kind of ease of administration, maybe, if you're getting at that, I think there too, I think if you constrain district courts and kind of force them into the framework, at least more than our current system does, force them into the framework that Congress designed, then, it's probably going to be not only more uniform, but, more predictable, more kind of easier to administer on the ground.
And just and it might be more fair, because it shouldn't depend on who your judge is based on what sentence you get. In other words, there shouldn't be a lottery that a judge matters in that, in the way it does today. Because when we're at the Court of Appeals, we often have to affirm, because of the deference given, rightfully so, but sentences that are polar opposites for the same exact crime. And that, to me, I think to Justice Alito, people talk about fairness. I mean, that seems a little unfair. And maybe, we should, as Justice Alito often says, to Sarah's point, maybe we should leave to the legislature and others the job of setting the punishment, and then have the courts apply that equally and fairly without regard to race, gender, and other things. And when you look, so maybe not a great example, but before Booker, in early Bush administration, they passed something called the PROTECT Act. And the PROTECT Act was aimed at really narrowing sentencing discretion. Okay, so narrowing it. When you look at that, that is the time, if you look at statistically, when race, gender, all those things didn't matter. So after Booker, there's another study that shows for the same exact crime, women got 35% less time than men. Blacks would get more time than whites, same crime. All of this came with the discretion given to sentencing judges. And so what Justice Alito, again, it's systemic. People say, oh my gosh, no, it's systemic. He's pointing to all these things. There are consequences to what the court's doing, and he tries to put them front and center.
Hey, excellent point. Commissioner Cassady, anything, or?
I don't have anything to add on this one.
Okay, well then let me move to a consequentialist one that will be a lot of fun to talk about. I'm gonna ask one of you, unless you want me to do it, but I don't want to steal it because it's so much fun, to introduce arguably the most famous criminal dissent that Justice Alito ever authored, which is Mathis. And then we can talk about the we can talk about the categorical approach to ACCA. Does anyone want to talk about Mathis, or should I set it up?
You can
wanna do it?
I can talk about it, or you can set it up.
Let's do it together.
Okay, you start with the GPS and
Yeah.
then I'll.
Yeah, so I'll tell the GPS story, and then maybe you can explain Taylor and the categorical approach. Okay, great. So Justice Alito begins his dissent in Mathis, 2016-ish, roughly. Commissioner Cassady, this isn't your clerk term, is it? No. Okay, it's roughly, it's in that area, so I want to make sure. With one of the most hilarious anecdotes to appear in the United States reports. He talks about this woman who lived in Belgium, and she sets her GPS to go pick up a friend in Brussels from the airport, and she gets into her car and starts driving, and she's following the directions in the GPS, and she thinks nothing about, she's just blindly following the GPS, and she travels hours through the night. She ends up spending the night along the road. She crosses multiple countries, and she just keeps driving. Like, she lives in Belgium. She is a Belgian woman, and she's just going to Brussels, which if any of you have ever been to Western Europe know is not a particularly large country, at least by Texas standards. And she just keeps driving and keeps driving and keeps driving and driving, and she eventually ends up in Zagreb, 900 miles away, after multiple days on this long journey, but she at least can rest easy knowing that she followed her GPS. And this relates to the categorical approach. How?
So that is how he starts, and in the showing that, setting everything else aside, whatever you think about Justice Alito, he's brilliant, right? He takes something like that and ties it to the categorical approach in a way that makes perfect sense. So the categorical approach really starts with a case called Taylor. And the idea is we've got to determine, right? You qualify. So let's just use this example. You're a 922G1, which means a felon in possession of a firearm. You get up to 10 years. But if you're an armed career criminal, you get a mandatory minimum of 15. Right? I think I got those
Yeah, and then
right.
an enhancement.
Yeah, and then there's enhancements and all that. Okay. How do you figure out if someone's an armed career criminal? Well, they have 3 prior violent felonies. How do we figure out if they're violent? Right? Now I'm going to take a pause and I say, if I go out on the street and I ask someone, I think as in Taylor, if you punch your girlfriend who's raising 3 of your kids, is that a crime of violence? And 100 out of 100 people are going to say, yes.
Not a trick question, right?
But then you come back to the federal courts, right? Following our GPS. And we start looking at, well, what are the elements of the crime? And not only what are the elements of the crime you committed, but what are the elements of the crime that could be committed, in the simplest way to explain it. And if any of those elements are nonviolent, it's not a crime of violence. It doesn't matter that every time you commit this crime, it's a crime of violence. Justice Alito says there is a simple solution to this problem. You've taken us down. We're now district courts. We just spent in an en banc 100 pages trying to figure out whether armed robbery was a crime of violence. Okay? You laugh. Our court said no. But I dissented. But Justice Alito's point is really simple. There's an easy way to do this that doesn't take up all the district court's time and the attorney's time. And it's, let's look at the facts. And if they punched their girlfriend, they raped someone, or they murdered someone, it's probably a crime of violence. And district judges are smart enough to figure it out. And if the government can't show what they did, because everyone's like, oh, the state records might not be good, that burden falls on the government. Like everything else, you want to prove someone's violent, prove they're violent. Everyone in America understands this, yet, and everyone sees how unworkable this doctrine is, and how much courts struggle with it, and how now, with looking at elements, In my jurisdiction, if you're on one side of the Ohio River in Ohio, it's not a crime of violence. The same exact crime is a crime of violence in Kentucky because they might not have a means of committing it that isn't violent. So depending on which side of the river you're on when you punch your girlfriend, shouldn't do that, right? Crime of violence, no crime of violence. It's preposterous. And yet, even though we can all see it, this comes back to the GPS, we still keep following it. We're 900 miles away from where we began, and yet we're still driving.
The first case I ever had as a federal judge, literally the first day I ever put on a robe, categorical approach, question presented, is second-degree murder. Guy beat his brother-in-law to death with a baseball bat. Is that a crime of violence? Well, we held yes, but there was a very colorable argument that it was no, because there were hypothetical ways that one could commit second-degree murder in Missouri, which was the relevant jurisdiction, without using violence. We had an entire en banc argument about, for those of you who are in federal courts or have taken federal courts, totally hypothetical questions about assisted suicide, like is that a crime of violence? What about, like the Jack Kevorkian kind of stuff? That was the whole en banc argument was just about these sort of hypothetical questions. It had nothing to do with the actual facts of this guy and his actual felony conviction.
And yeah, I mean, it was crazy. When we had the armed robbery case, my law clerk who's here spent all of Christmas break reading every Ohio case to figure out if there was a way you could commit armed robbery and robbery under Ohio law in a nonviolent fashion.
Yeah. But this obviously is absurd, and lots of judges have talked about how absurd this is. But let's probe these two. I want to talk to Justice Campbell and to Commissioner Cassady about sort of how our themes about Justice Alito cash out in this particular way. So let's talk about theory and deference for a second, Justice Campbell. Like one of the responses, and Justice Alito has written this, I think he wrote one of these in my term in a case called Chambers, is that, look, ACCA, it's not just ACCA, right? It's also, there's a provision in the INA that has a crime of violence thing in it. There's a provision in the sentencing guidelines that has a crime of violence provision in it. And he said, look, only Congress can fix it. Congress hasn't fixed it, so let's just keep on, shouldn't we just keep following the GPS for another 900 miles? What do you think?
Yeah, I think building off my earlier comments about, respect for the elected branches, I think that the GPS opinion just so well points out like how absurd this is. And, Judge Thapar mentioned if you go and ask the average person on the street if one of these fact patterns is a crime of violence or a violent felony, then of course it is. And I think that's, I think one of the themes in his ACCA jurisprudence is like, look, we know what Congress was trying to do here. And we're just, I think he called it pointless formalism. And I can't remember if it was a Mathis opinion or a different opinion, but, we're engaging in pointless formalism here. And we are just missing the whole point of what Congress was trying to do. And, that of course is essentially usurping Congress's authority. For the court to engage in that kind of pointless formalism when it's just getting so far from what Congress intended in ACCA. And so, I think it absolutely kind of picks up that theme that we were talking about earlier. And I mean, these hypotheticals, y'all, are just, they're just crazy, right? I can't remember if it was in an opinion or just an oral argument where the court was talking about, whether you could, if you murder someone by starvation, like by starving them.
Yeah.
Well, that means that, that murder can't be a crime of violence. So it really ignores reality to not even consider, the facts on the ground and what happened in a particular case by favoring that kind of formalism.
Well, to play devil's advocate, I'll do this with Commissioner Cassady because as you know, I love to play devil's advocate.
Yes.
Why wouldn't the whole point of Taylor, 1990 Taylor, again, there's multiple Taylors, but the one that we're talking about is the Big Bang or the origin story of the categorical approach. The whole point of the Taylor idea was to create a clear administrable rule, right? We're going to do this elements approach. We're just going to compare the elements. We're not going to get into the factual records. The court goes on at some length and says, look, maybe the factual records don't even exist. So how are we even going to be able to do this? And we need to have clear, bright lines, right? And so we're going to look at the elements of the crime that was committed by hypothesis under state law. We're going to compare that to the, burglary, robbery, whatever the examples are, or the other crime of violence, the residual clause. And super simple, clear, administrable, bright lines. And, Commissioner Cassady brought up earlier, well, sometimes one of the problems with clear, bright lines is it comes up with harsh results, or maybe you end up having to have an en banc argument about whether murder is a crime of violence. But such are the breaks in the big leagues. What do you say to that criticism?
So I think that the way I would respond, and I'm by no means an expert on the ACCA jurisprudence or whatnot, but I think I would just say part of Justice Alito's rules-based approach also features a willingness to, because he served as a circuit judge, and he, as someone in another panel mentioned, he's said before, what matters when you're in that position is having clear administrable rules. And so I don't think Justice Alito would say, well, we did this in 1990, we made a clear rule, and so just live with it. I think he views it as the court's responsibility to have sort of a feedback loop with lower courts. And if it's turning out that what seemed to be a clear rule that flowed from the statute's text is leading to results that in no reasonable world are consistent with what Congress in context actually wanted to do. Like, for example, saying a violent felony that increases your sentence under federal law is a burglary. But it turns out that all the burglaries in the largest state in the country don't count under the approach you've adopted. I think Justice Alito would say something's gone wrong here. So I wouldn't say that his approach to favoring standards is very sensitive to whether or not the court's decisions is having real-world impacts that might, if they're going awry, it might say that the court needs to check its work and maybe call home.
Mm-hmm. So let's talk about something that comes back to sort of, I think both Commissioner Cassady, you and Judge Thapar had both brought up, Jones, maybe also Justice Campbell, brought up Jones and Katz. That evokes in my mind another series of sort of search and seizure kinds of cases that Justice has written about. Which is the so-called Belton doctrine. So for those who, again, are not career prosecutors or federal district judges or magistrate judges who have to sign warrants every day, the old Belton rule is not that old. It's a 20th century rule, but the gist of it is incident to an arrest, a police officer can search the that occurs like on a roadway or involving occupant of a car. An officer can search the passenger compartment of the car. So that's the old Belton rule. In a case called Gant, the question presented is, okay, well, should we just continue following the Belton rule, or do we need to create some sort of exceptions, or do we need to make it more complicated for searching the passenger compartment of the car? And the court says, look, we're going to create this two-part test that's going to be slightly different, slightly nuanced, slightly more difficult perhaps for officers to apply, which is what prompts Justice Alito to dissent. But I guess one of the questions that comes up in these things is there's obviously this bright line question, is that it's always better to have a bright line rule perhaps than to have a two-part test that's a little bit harder. But what do you do when the original rule, so in this circumstance, Belton, or the original rule, for example, and the one that I think all three of you discussed, Jones, which was the Katz reasonable expectation of privacy, what do you do when the underlying rule has some, let's just say, complicated relationship with originalism? Is that a politic way of saying it? What's the sort of, how would you characterize Justice Alito's approach in those cases, to any of you?
Do you want to?
Well,
Go ahead.
I suppose I can start. So and a couple of other panelists have discussed this about Justice Alito's originalism, how he's described himself as a practical originalist. And I think in the area of, and how he respects precedent, he has a high threshold for just revisiting a whole line of doctrine on which everyone's come to rely, especially in the area of criminal law and criminal justice, where people in the criminal justice system on the ground floor have been doing things the same way for years, and they need clarity and stability. And so I think that Justice Alito has that respect for precedent, especially in this area, is baked into what he thinks it means to be an originalist and exercise the judicial power. So with that being said, I think that in some of these cases where, as Judge Oldham said, it could be criticized, say, the exclusionary rule or something, which says the fruits of an unlawful search or seizure cannot be used as evidence in the criminal case. To the extent that has maybe a complicated relationship with originalism, I think one of the ways Justice Alito has very ably kind of dealt with developing new doctrine while also not going beyond where the maybe non-originalist doctrine is by remembering the purpose of why the rule exists in the first place. So one example of this related to Belton is Davis, where a follow-on case where Justice Alito wrote that even if you had conducted a search under the old rule, and in the meantime, while the evidence comes in and then you're on appeal, and then the new rule comes down making the search retroactively illegal, the exclusionary rule doesn't apply. And so Justice Alito says, look, we have to look at the purpose of the exclusionary rule in the first place on its own non-originalist terms, which is to deter police misconduct. And so Justice Alito says, look, how would applying it here contribute to that functionalist, non-originalist goal? It's one thing when the constable has blundered, he said, but it's another thing when the constable has conducted a search in scrupulous compliance with existing law. And so he respects the non-originalist precedent, but doesn't extend it in ways that outstrip its purpose.
Yeah, I mean, that's a fabulous answer. And the only thing I would add to that is I think when you think about what Justice Alito does and he looks at non-originalist precedent, what he doesn't want to do, and what he talked about a little in Jones and some of the other cases, is take a non-originalist precedent, add some kind of theoretical-based originalist precedent. Okay, so now you've got two kinds. You've got reasonable expectation of privacy in the Jones world, and you've got the trespass theory. Not tell lower courts how to apply these, right? So now you've got two doctrines. Do you have to go through them both before you figure it out? One, if you've got one that's working and it's not clear, look, if it's clear from an originalist perspective it's wrong, I think Justice Alito would sign on to getting rid of it. But if all you're doing is adding layers that are unworkable or difficult to work with, what he says is, why are we doing this? This provides the answer and everyone understands how to do it. And now you're adding something no one understands how to do, and you're not telling them how to do it. And there's a common theme in his jurisprudence, which is, if we're going to do this, we better tell everyone how to do it, right? I think you called it do no harm is a way of thinking about it, but we've got to tell them how to do it. Like, you're going to get to mens rea, we're going to talk about that, but like, I mean, he's like, we can't just take these cases, create problems, and then let the lower courts figure it out. And if we've got a doctrine that the lower courts are ably applying, why are we monkeying with it?
Yeah, and I think something that really kind of permeates a lot of Justice Alito's jurisprudence and touches on all the themes really we've talked about today is, his judicial modesty or judicial humility. And, I think that's, Jones is a good example of, if there is uncertainty in, if the Constitution is indeterminate in some way, rather than have judicial innovation, by tacking on this trespass theory in the Fourth Amendment context, maybe let's wait. Let's wait and kind of see how this all works out. Maybe we let the legislature figure this out. They're in a better position to, respond to rapid evolutions in technology and weigh all of this. But, if we're not sure about what the Constitution says about this, then let's not kind of aggrandize the judiciary or ourselves by, thinking that we have the answer and only we have the answer and can solve this. And I respect that, I think, so much about Justice Alito. It's judicial modesty and humility, but it's also sort of an intellectual humility. I think we see this I think this is part of the reason why he wants to make sure that the court's guidance is clear for lower courts. The Supreme Court shouldn't be an ivory tower that just makes pronouncements and kind of leaves it to the peons below to figure out, what to do with it all. And so I think that can explain, some of his approach to originalism as well, and maybe his, reluctance to go as far as quickly as some of his colleagues.
Well, let's pick up right there on sort of judicial modesty, and also I think, Judge Thapar, you just mentioned mens rea. So let's talk about that for a second, because it kind of ties together some of these themes. So I'll throw out a case, I'll lay it out for everybody, and then we can kind of unpack it, because I think this is also going to bridge nicely into habeas. So let's talk about the case, the Alonis case. I may be butchering the surname. But for those who are not presently in 1L crim law, quick CLE refresher, 4 basic mens rea in criminal law. There's negligence, recklessness, knowledge, and purpose. Those are the general mens rea from least culpable to most culpable. Blackstone famously said that to do a criminal act without one of those mens rea is not a criminal act at all. So take the case of aloneness, where the North Carolina state legislature defines a crime but does not define a mens rea at all, right? So there's 4 choices, of which the state legislature gives us 0 data as to know exactly what we're supposed to choose.
The crime's threats, right?
Yeah, I think it's threats, exactly. We could also do rehave, where there's 2, it's a compound crime, right? Where there's a mens rea in one part and not in the other part. So we're basically, this is gonna push a little bit on theory and deference, because there's the legislature's not giving us something to defer to, and now we have to, as a court, look at this and say, okay, well, what do we think the right answer is? In aloneness, if memory serves, the Court of Appeals picks negligence, the least culpable of the 4, and the Supreme Court of the United States reverses, says it's not negligence, but then does not specify which of the other 3 it could be. So we know it's higher than the bottom, but we don't know if it's 2, 3, or 4 on the level of culpability. Justice Alito says, Marbury versus Madison is emphatically the province of the judiciary to say what the law is. Part of the law declaration function is to let people know what the rules are so that they can conform their primary conduct accordingly, so judges can rule accordingly, so that people can, behave in accordance with law. So we need to tell everybody what it is. If memory serves, he proposes recklessness, so that would have been the second. But there's no real response from the majority. What does this sort of help us understand about the justice and his approach to criminal law or law generally?
Yeah, I mean, I think this is a great case because you left out the punchline. He's got a wit. Justice Alito has this wit, and he says, Marbury says it's our job to say what the law is, not what the law is not. Yeah. And all the majority did is they said it's not negligence. Now, you lower courts figure it out, but think about that. Like Justice Alito points out, people are now going to go through trials. We're not going to be sure. Like he proposes something. He says, look, I think it's reckless. Here's why. But let's say it gets back and they say, no, reckless is wrong. That's too low. Mm-hmm. Right now, there's people that have served time in jail. Right? Everyone that says, oh, Justice Alito is anti-criminal. Wait a minute. This decision is, in some sense, pro-criminal. It's saying, I don't want people to serve time in jail while the lower courts figure it out. I thought the majority said, maybe I read this somewhere, oh, well, they didn't specifically file briefing on this. And Justice Alito, I think, points out, maybe I'm dreaming all this now. There's something called supplemental briefing. Also, the Supreme Court kind of, with all due respect, does what it wants, right? It picks what issues it wants to decide. It decides those. But I think to let this percolate in the lower courts has some real consequences. And so Justice Alito's saying, look, we know it doesn't include negligence. What does it include? Why don't we end this and tell everyone what it includes so everyone knows? That would make a lot of sense. Instead, we're just going to send it back and let the lower courts flail around for a while, and then we'll tell them.
I assume a prosecutor would tell us the same thing. You'd rather know what the standard is before commencing the prosecution than having to guess 8 years later when it goes to the court.
I agree, and I don't have a whole lot to add to that other than that is, everybody in the system benefits when you know what's going in the jury instructions and you know what, from the beginning, what you're going to have to argue to the jury on either side, and Justice Alito showed a keen awareness of that.
Didn't want to jump on, sorry, didn't want to step on toes. So let's talk about rehave for a second. So this is a similar sort in the same kind of bucket of issues. But in this case, there's 2 separate provisions. There's 922 and 924. There's a mens rea provision in one. There's not a mens rea provision in the other. One of them involves alien status, and the other involves possession of a firearm, right? So we have 2 different provisions. They're not even in the same statute. They weren't added at the same time. They're governing different sources of conduct. One is about whether and to what extent your immigration status comports with the INA and ARERA and the Real ID Act is amended. The other one goes to gun possession, et cetera, so different concepts. The Supreme Court of the United States says we're going to take the mens rea provision from the gun provision and apply it to both elements, right? So you're not actually committing the relevant offense unless you knew both of your unlawful alienated status and also of your possession of the firearm, right? So it's got to be both of those things. And Justice Alito dissents and says, number one, that's not how we read statutes, not to tread on the statutory interpretation panel. And number two, think about the consequences of this because of the retroactive, it will necessarily be a retroactive effect. He says, look, because of the way that the court has written this opinion, what the court has said is we are redefining the elements, right? That is to Commissioner Cassady, I'm particularly solicitous of your real world prosecution experience in this. And Judge Thapar, you were also in AUSA, so you know what it is like to have to go in front of a grand jury. You know what it's like to have to stand in front of a judge and ask for jury instructions. And you know what it's like to argue in closing argument that you've met beyond a reasonable doubt standard as to criminal offenses. In Rehafe, the court says, look, here are the elements, and there's now a new element, right, which is knowledge, or I can't remember if it's knowledge or purpose, but one of the sort of higher end mens rea requirements has to apply to both of these things. And because of that, it's necessarily not going to apply just to Mr. Rehafe, it's going to apply to everybody who's in prison for years going backwards. They will now have habeas applications and post-conviction motions that they can file to argue that they were convicted without sufficient evidence because the government obviously did not know that they had to present mens rea evidence as to those elements. What do you think?
Go ahead. No, go ahead, Judge.
So it was knowingly applied to both, I think, and it just creates all sorts of issues, right? Because now, here, to get to Sarah's point, the kind of Thayerian deference, I don't want to call it pure Thayerian deference, but Thayerian type deference, Justice Alito said, you know, Congress gets to write the laws. It's pretty clear what they wrote. And just to take Alanis and Rehafe together, you're not going to tell what goes in this one, so we're going to let them flail around. And then we're going to do the opposite here. We're going to add something that never existed before, and we're going to transpose it from one area to another. And now we're going to say not only that, but it's basically retroactive, and good luck, lower courts. And so you've got this area where knowingly now, and they were applying it to the alien status, right? So the alien had to know that they were illegal at the time or not welcome anymore. In other words, their visa ran out or whatever. The trials already happened. The pleas already happened. And now they challenge it, and the government's got to show that they knew that at the time they committed the crime. It's not workable in any form, and it's supplanting what Congress explicitly did.
Yeah, please.
Oh, no, I don't have anything to add.
So what do we think about, though, about the consequentialist argument? I mean, so like if you, just imagine the Rehafe court is right, though, right? If the Rehafe court is right, and that in fact the elements were more sophisticated than what we originally thought, right? We originally thought there was mens rea to one, but not mens rea to the other. Now we know there's mens rea to both. Why shouldn't that apply to everybody retroactively? Why shouldn't it, you know? I mean, this is the problem that comes up in all of these retroactivity cases. What wouldn't, I mean, if your client, if you were a public defender and your client was in jail, wouldn't you want your client to get the benefit of that rule?
Yeah, you know, I think certainly if that were actually the right result, it would be a very different question. But, you know, I think, and I think you made this point earlier, that, you know, sometimes it's the very fact that you're going to have consequences so sweeping, you know, from a particular result that should give the court pause and should kind of make the court question whether that's actually the right result or not. I mean, I think if that is where, you know, if that is what the text requires, that's where the text leads, then, you know, you're going to have to deal with those consequences. But, you know, I think that's just, it wasn't the case. I think in that particular decision, or in, I guess, Ruin was one that followed not too long after, where the court sort of took what should have been an affirmative defense and made it an element of the crime. And, you know, in both situations, it was sort of the court, you know, kind of going out of its way to create a problem, a practical problem. And I think, you know, the fact that you have that practical problem is just maybe a reason to think twice about, you know, whether that's the right result.
Well, I see I appreciate that very much. We have about 10 minutes or so left, and so I want to make sure that we get to some audience questions. I'm so sorry that I could do this all day. We never got to Thenorosum or the Eighth Amendment. So a fruit basket for anybody who wants to talk about habeas and immigration. But should I call? Or, yeah, I'm happy to. Let's start in the front.
Thank you. I wanted to highlight a respect in which I think Justice Kennedy's criminal procedure jurisprudence was more originalist than Justice Scalia's, and it bears on the Jones case. And that is that Scalia believed very firmly in the idea that the rule of law is a law of rules. And so he wanted everything to be a rule if possible, like the president has to be 35 years old, or there can be 2 senators from every state. He tried to take clauses that were standards, like no unreasonable searches and seizures, no cruel and unusual punishments, no prohibiting the free exercise of religion, and turn those clauses into rules as much as possible. I mean, one thing he might have been doing in the Jones case is you could argue about what is an invasion of privacy, and that's arguably more of a standard, but figuring out whether a property right's been invaded is maybe more of a rule. And so I wonder whether any of you think that he was wrong, that Justice Scalia was wrong in trying to cause provisions that created standards to read them as if they were rules, and whether in that respect at least Justice Alito is perhaps more originalist than Justice Scalia was.
Great question. What do you all think? Not on board with trespass to chattels and Jones. So what do you think? Sure. I'm happy to do it, but I don't want to
Go for it.
I mean, so I think that Justice Alito's originalism is often underappreciated. So I appreciate the question very much. And I think that that's a great example. One of the ones we haven't really gotten a chance to talk about is Justice Alito's criticisms of the Confrontation Clause cases, starting with Crawford, another place where he and Justice Scalia disagreed. And I think that a lot of Justice Alito's criticisms of that doctrine and of its consequences and of its provenance have been proven correct. So
The interesting thing, just to add one point in defense of Justice Scalia, is I think Justice Scalia was, I agree with everything Andy said. I think Justice Scalia's idea at rules is similar but different to Justice Alito's idea at workability, which is rules are easier for lower courts than standards, and we get a level of consistency. Now, that doesn't always play out, like you just pointed out. In the trespass doctrine, I mean, I think it creates a lot of issues. But it was an admirable goal, similar to Justice Alito's. I just think Justice Alito, in his entire jurisprudence, isn't as rigid, and he's going to look at how, he's not going to have what I call rigid formalism, whether it's in textualism where he's a contextualist and going to look at the context, whether it's in constitutional interpretation where he applies common sense. I just think there's a level of how does this, I get it, the theories in the halls of academia are a lot of fun, right? But I want to pay attention to how this is going to operate on the ground floor, which is our first and foremost responsibility in his mind. And I can tell you, I think as lower courts, we definitely appreciate that.
other questions? That's great, right here in the middle. Wave at me if I'm missing you. I don't mean to be biased for the middle.
Thank you. I was wondering about the recent U.S. versus Hamani case about the Second Amendment and disarming habitual drug users. I know during oral argument, Justice Alito pointed out that a lot of drugs didn't exist at the founding, but then Justice Thomas pointed out that like alcohol users couldn't be disarmed unless they were very dangerous. So if there's an analog to a current criminal law that's not a perfect fit, would Justice Alito maybe require a more tight fit than Justice Thomas would?
What do y'all think? Alito versus Thomas?
Would he require a tighter fit? Was that the question? I mean, I don't know that he would require a tighter fit. I think he does, focus more on, as a lot of people have talked about, right? He has more of a common sense approach. So, I don't think he's going to require like an exact historical analogy, right? I think, but I also think he's maybe more likely to, to just think about the practicalities rather than, I do think he would allow for maybe not necessarily a looser fit, but he may not require a historical analogy at all if he can identify sort of the principle from, the Second Amendment or the constitutional provision and, find that applies in a sort of common sense way, with analogical reasoning, to the current situation. I think even if there's not a precise historical analogy.
I also think, to Sarah's point earlier, he again is going to give more deference to the legislature. So before he starts cutting up and chopping up legislation or striking it down in any way as applied or on its face, he's going to want to see that it's pretty clear from the history that that was banned or that was a way that you could. In that case, drugs and alcohol, I think he wants to be certain before because the court's taking away the legislature's ability to say a drunk with a gun is dangerous, for lack of a better way of saying it. He wants to be sure he's entitled to take that away from the legislature.
Yeah, I mean, the Miranda rule didn't exist until the middle of the 20th century, and he had no problem applying it in JDB. Belton didn't exist until the middle of the 20th century. He didn't have any problem applying that in Gantt. And Katz didn't exist until the middle of the 20th century, and he didn't have any problem applying that to GPS devices in Jones. So I agree with all of you in the way that you sort of think about that. Is like the clarity of the rule and the ability to apply it and its administrability is as important or more important.
There's that great line in his opinion in Jones about, the tiny constable. It would, like whether a constable could have secreted himself
For
in a
28
coach
days.
for 28 days,
Yeah.
and he just kind of points out how absurd that just even the attempt to think about, that analogy is.
I mean, there's even a meta-analogy in that case because GPS devices did not exist at the time of Katz. Like, obviously, they didn't exist at the time of the founding, but they didn't exist at the time of the lights or whatever, the glow lights, that kind of thing. So,
Over here.
I can't see. Oh, sorry, right there, excuse me.
Might have to be the last one.
So it was funny that you mentioned Miranda. Can you hear me?
Yes.
It's funny that you mentioned Miranda because my question related to Vega, where Miranda was seen as being undermined. And I'm just wondering, do you think there's appetite on the part of Alito to address some of those Warren Court criminal procedure and rights cases like Miranda, like MAP, which really did not have good originalist justification and which have been harshly criticized for potentially some of their effects and preventing states from experimenting with different models? And if there isn't such an appetite, what do you think sets those cases apart as sort of protected from originalist review?
You don't think?
I think as to Miranda, I find Miranda really interesting in the sense that if you think back to, is it Dickerson, where the Supreme Court got Miranda, you all will remember who wrote Dickerson was Chief Justice Rehnquist, who was probably, at the time he might not have been the chief, but he was,
2000,
okay.
yeah.
So Chief Justice Rehnquist, and he was very, people considered him more kind of rigid and would be anti-Miranda. All law enforcement weighed in on Miranda's side, which was interesting. Why? To go back to the theme of this, because it was a doctrine that was workable for law enforcement. They understood it. We got someone in custody, we advise them of their rights, we're good. We can get them to sign this sheet, they understand their rights, boom. A clear rule, easy for law enforcement to apply.
Yeah.
And so just Miranda kind of on its face, I don't think anyone right now is just trying to get rid of it because it was tried once. I think it was 7-2 in that case with the chief writing. And I think because of how workable it's been for law enforcement, it's better than the uncertainty of what existed before that in their minds.
Yeah, I mean, Justice Alito also dissented in Ramos, which is a case where, where he talks about there was an old rule called Apodaca that let two states have non-unanimous jury verdicts, and the justice says, look, there's reliance interests on this, and so he dissents when the court overturns it. And so I think the answer to your question, anytime it's stare decisis, reliance interest is obviously really important, and he's written on that too. So I think that we are officially out of time, but please join me in thanking my distinguished panel.